Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I am the Extension Legal Specialist here in the Department of Agricultural and Resource Economics at the University of Maryland. And we are back today with a new episode focused in on this time on right to farm laws again and sort of the use of scare guns. I had recently posted an episode looking at Wisconsin, where two farmers had been zoned out in the right to farm law did not protect them in that case. Today, we're going to talk about Mississippi and some issues there and how the right to farm law actually did work. So it actually does show that although, one case it comes out one way, the other case it comes out another way, just based on how it's being, the process that's being used, the results are different. And if you have questions on that, my information's at the end. We can talk and you can email me. So to start off today, we need to look at in Mississippi, we had these two producers who began to use propane cannons / scare guns to prevent deer damage from their cotton and soybean crops during the summer months. The propane cannons created loud noises, and the neighbors in ensuing lawsuit tried to prevent the two producers from using the cannons, claiming nuisance. The trial court agreed with the two producers that the state's right to farm law barred the nuisance claims, and the Supreme Court of Mississippi recently upheld the trial court's ruling in Briggs v. Hughes. So let's give you a little bit of background on this. In 2018, neighbors of Penn and Hughes, two producers who farm cropland near the neighbors, brought a nuisance suit against Penn and Hughes to prevent the use of propane cannons. The neighbors complained that the loud noise from the cannons impacted the use and enjoyment of the neighbors' property. At the trial, the court never reached the issue of the propane cannon being a nuisance. The court found that the state's right to farm law barred the neighbors' lawsuits. Mississippi's right to farm law requires that the agricultural operation exist for at least 1 year to gain the defense against a nuisance claim. The trial court determined that the two producers had utilized the propane cannons for more than a year before the lawsuit. At the same time, the trial court determined that using the propane cannons was the best management practice in compliance with state and federal permits, additional requirements that are in the state's right to farm law to gain the defense. The neighbors appealed this decision. So let's look at the Mississippi Supreme Court's decision. On appeal, the first issue the court dealt with is whether the trial court erred in determining how the law applies to changes in operations, adding in new practices. The neighbors argued that the Mississippi legislature did not create a blanket protection for operations adding in new practices on a farm. The court should look at when the practice began to be used. The court disagreed with this view of the state's right to farm law. To the court, the legislature changed the law in 2009 to remove language supporting the neighbor's argument. Before the changes, the law required the court to take into account the conditions or circumstances alleged to constitute the nuisance must have existed substantially unchanged since the establishment date of the operation. Looking at the language now, the court only has to determine if it complies with all applicable state and federal permits. One judge concurred with the decision, but would have come out differently on the issue of how to apply this language in the state's right to farm law. To this judge, the language required the court to look at the exact date the agricultural activity, in this case, the use of propane cannons, began, and not when the overall agricultural operation began. The judge also held that this view had been adopted by other jurisdictions as well, including Texas, Washington, and Idaho. The majority rejects this view because the language of those states is different than Mississippi's. So we have this one judge out there who agreed with the plaintiffs, but he concurs in the decision because his basic view was, if you look at it, the propane cannons had been used for more than a year when the neighbors complained. So now the court then turns to the question raised by the neighbors that the use of propane cannons was not a best management practice. The neighbors argued that expert testimony demonstrated that propane cannons would become less effective over time and that the cannons could not be a best practice because they were not always practical. The question is not whether the practice is always practical, but whether the practice follows best agricultural management practices to the court. Here, the expert testimony showed that propane cannons were used appropriately for pest control, and the court refused to reverse the lower court's findings. The court also rejected neighbors' arguments that the two producers violated the Mississippi criminal statute, making it a crime to willfully disturb the peace with an explosion of gunpowder or other explosive substance, or through a loud or unusual noise. The court disagreed because the trial court had found no evidence that the two producers had willfully intended to disturb the neighbors. Finally, the neighbors argued that the trial court's interpretation of the right to farm law violated the neighbors' rights to due process under both the U.S. and state constitutions. The court disagreed, highlighting again that the interpretation was within meaning of the statute. At the same time, the court highlighted that the state's constitutional challenges require the Attorney General to be notified and given a chance to intervene in the question of constitutionality. That had not been done here, so the neighbors could not challenge the constitutionality of the law. The state Supreme Court upheld the trial court's decision and did not find an error in the decision. So why do you care? Well, like I pointed out at the start, you may be thinking, if you remember the Klein decision, the one out of Wisconsin I talked about recently on here, you might be thinking we're having different outcomes than that decision. We really aren't. In Klein, the issue was that the town changed the zoning ordinance to prevent the use of scare guns, with no claims that the scare guns were a nuisance, requiring the application of the right to farm law. Here we have a town going about a different way to handle this issue of scare guns. In this case, Briggs versus Hughes, we don't have that problem. We have neighbors complaining about, this nuisance created by these propane cannons, in the court applying the right to farm law. So we have basically, two outcomes that are different, but what's being done to get to that outcome is different in this case than it is in the Klein case. In Klein, we have a zoning change. Here we don't. This case also shows that when an agricultural practice is claimed to be a nuisance, the court will look at how to apply the language of the right to farm law in the state to determine if the practice is protected. We can't really infer sometimes how these rulings will be used in other states because the language could be different. We may have similar parts of our laws that are the same, but there may be other parts that are different. Again, if you have questions on this, I will post a link to the blog post where you can get to the court ruling and other things if you're interested in it, and also information on Maryland's right to farm law as well. Thank you again for listening. If you have any questions, please email me at lgoering@umd.edu, or you can tweet me or find me on Instagram at aglawpaul. Thank you again for listening, and enjoy the rest of your day.